It's okay, the witness can step down. I just wanted the jury out of the issues we've been moving around the court with the jury. I just wanted issues with security questions. So, Attorney Sisley, do you have any further witnesses after this?
No further witnesses.
Oh, so you'll be resting at this point.
Resting anyway.
I'm sorry?
Resting and redo with the motion.
Resting with new motion, fine. Given late hour, obviously we're not getting to closing arguments for charging. So if I do want to talk about jury instructions while we're still here, after we'll bring the jury back in a moment, we'll use the jury, and then we'll plan for tomorrow. I'd like to try to start tomorrow morning, if possible, at 9:30.
I'll be
Here. All right.
although, yeah, I'll be there. I was just telling Doc, I got this emergency recall thing. I think they open up the service here at 7.
All right. Drive safely.
Do we do?
Great. All right, so 9:30 we'll try to start because I do want to get to the jury as quick as we can tomorrow. I don't know what the, April, maybe you can help me. Friday's an admin. I know this is resume, but is it possible that the jury is not confused tomorrow? We can go and Friday, like deliberation. My preference would be, assuming the jury gets this case tomorrow, assuming the time they need to say to get it around lunchtime, right? 9:30, 10:30. Let me get this done lunchtime tomorrow. If they go beyond tomorrow, Friday's technically an administrative day, but I would want to keep them having it ready Friday. Workable for everybody?
Yes.
I agree.
Good. All right, very good. So let's take a minute, and then we'll come back. We'll talk jury instructions. Are we ready to do it now?
That's fine.
All right, let's do it right now. Jury instructions.
Mine were pretty simple, Your Honor. There was a typo wherein the defendant is referred to as Justin Levesque. That's on page 13. Discussing charge number 2, the first degree assault charge is in the second line.
Line what? Page what?
Page 13,
Oh, 13.
Roman numeral 2, line 2.
All right. All right, next.
My other was just more of a formatting issue. Based on my read of it, it seems like it would make more sense to put the self-defense instructions after all of the charges have been read versus after the first one, since it does apply to all of them.
Yeah, I've seen it done both ways. I think given that self-defense is, I thought about that. Self-defense is technically, disproving self-defense is an element of the crime.
Right.
And where I'm going through and saying these are the elements that we have to find, I think logically it makes more sense than to say, and by the way, let's talk about self-defense. This is the element. I don't repeat it fully because I think that would be a little overkill. Then to do the whole thing again and instead I refer them back. I hear what you're saying. I've seen it done that way, but I've also seen it included as an actual element. I think this is the way it strikes the better balance. Maybe that way, but I don't know. So, Assistant, do you have a concern about that?
I prefer the way it is.
Okay.
That's fine. The one other thing I had too was there's a paragraph about expert witnesses on page 7. The only expert that I'm thinking of, and I may not, but he wasn't certified as an expert. He was a fact witness, so I think that entire paragraph can just be cut.
I'm happy to take it out.
Yeah, I don't think it makes any difference.
Doesn't make any difference. The expert comes out. And I forget. I don't have the defendant not testifying language. Do I already take that out?
That should be out.
I should.
Be out. It's often included in one. Perfect. I mean, by accident. So I just want to make. I'll check it. That's probably should be out. But I think I've seen these things. All right. Consistent.
Yeah, let's stay on page 13.
13.
Easy one first.
Big part.
The defendant is charged with one count of first degree. We have to say.
Oh,
Look at that. First degree murder.
none of it is there. The name and that.
Okay, let's go.
I'm sorry, Jeff, what was the
First,
It just says first degree. It doesn't say
it
assault.
should be assault.
it should
Oh,
be-
assault. Oh, assault. Run. I'm sorry. First degree assault. I misspoke. Yeah. That's right. This is count 2. That's count 2. First degree assault. Yes.
Yeah, then Chris Croft, let me go back to Page 11, second paragraph of self-defense, last line. You should consider whether the defendants believe that it was necessary to use deadly force.
Oh, thank you. Yep, thank you. You'll probably guess, I cut and pasted these from a different set of jury instructions that dealt with non-deadly, and I tried to replace every non-deadly with deadly, but, all right.
Let's go back to 13.
Thank you.
Last sentence of the first partial paragraph. Thus, if you find beyond a reasonable doubt that the defendant was, you should say the initial aggressor.
Okay.
It doesn't have to be an actual.
Counsel, do you have an issue with that? I think that's...
You know, the only issue is that it doesn't bear on the facts of this case.
That's true. I mean,
Well, here's the reason. Because you have mixed statements, because it reads, a person does not have the right to use deadly force to defend himself if he or she was the initial aggressor. That's
Right.
page 12. So
Right.
let's stay with the same thing.
I mean, this isn't a case, this isn't really a case where there's that issue at play. It's in there because that's the standard language, but...
But, you know, my point is it affects the pattern affects a number of genres of self-defense. One of them being if somebody initiated it and then claimed self-defense.
Right.
That's not this case. Even though
There hasn't been an initial aggressor. I could easily take that out, and I wouldn't have an issue with taking it out.
Well, no, I mean, I guess I'm troubled by the actual physical force. You don't have to have that.
Right. But I'm saying the state, Attorney Barth is right, the state is not claiming and has never claimed that your client can't raise self-defense because he was the initial aggressor.
I understand that, but
And so there's probably no reason to have that paragraph in here at all.
I'm asking that it be included and that the terms be consistent. Aggressor, not aggressor, and first person to use physical force. The two are not equal.
I'm asking that it is excluded based on confusion of the jury about it functionally introducing legal concepts that don't apply and requiring them to draw factual inferences that don't apply. I mean, that's the nature of the scope of narrowing pattern instructions to fit a given case. It just doesn't apply here. There's no claim by the state that Jason Levesque is foreclosed from using self-defense because he was an initial aggressor. And so the jury shouldn't have to be wrestling with that notion. Wrestling with those legal concepts.
I think there's some merit to that argument. I mean, I do recall when I added it, I wasn't sure if that was going to be an issue that anyone was going to be raising, or whether you were going to be somehow claiming that the shooting was somehow the initial aggression, and that. But if you're not making that defense or that claim, I think it makes more sense to take it out.
If there's no indication that that's going to be the claim, then I really don't have a problem.
Just to be clear, the claim is obvious that he didn't have a reasonable basis to use lethal force. He didn't have use reasonable force,
Right.
and that there was no imminent use of deadly force against him.
Right. But you're not going to make the argument that you can't raise self-defense in this altercation because you yourself were the initial aggressor who didn't then withdraw because the initial aggressor has to withdraw. Otherwise, you're not making that argument.
No.
All right. Then I'm going to take out that entire paragraph. I think it will make things clearer for the jury. All right. Next, Attorney Sisti, what else?
Good.
Okay. You did all see my addition of the definition of serious bodily injury. I did add some language that's my own in there, just so you know that's not entirely the pattern language. It's largely the pattern. I added some language where I basically said, just because I think the pattern language is not great, it just tracks the statute. I do say something along the lines that a scratch, a bruise, those sorts of things aren't serious bodily injury. That serious bodily injury means, as the name implies, a serious or significant injury. And I track the language of the statute as well. Take a look at that. I want to draw your attention to it since I have deviated from the pattern. Attorney Sisti, you have no issue with that?
No.
Okay, State, you have no issue with that? Very good. All right, I'll make those changes to those. Although I will be back here, I'm going to bring the jury back, and then you'll rest on the record. I will give them their instructions. We'll send them home, and we'll be back here tomorrow morning at 9:30 for closing arguments and charging. Right? Very good. Let's bring the jury back, please. It is still hot in here. We have asked maintenance to turn the heat down to no avail. I clearly have limited powers. Oh, before the jurors come back in, do you want to approach this real quick? Do we have a second before the jurors get back? I was watching. By the way, ladies and gentlemen, I apologize for the sort of radically fluctuating temperatures in this courtroom. It's very hot today, at least in my opinion, and so I apologize. I appreciate you all putting up with that. We've tried our best to fix that, but we can't. All right, Attorney Sisti.
Yeah, thank you. Based on the state of the evidence, the rest of this.
Very good. Thank you. So as you just heard, ladies and gentlemen, the defense has now rested their case. As I explained to you at the beginning, that means the evidence at this point has now been fully presented. And the next step in this process are going to be closing arguments and then my instruction to you on the law, and then you'll be able to deliberate about this case. Now, the important thing to remember right now is that just because the evidence has gotten all admitted doesn't mean that we're at the deliberation stage yet. It would be tempting to think that now you can all talk about the case amongst yourselves, but you still can't. You still have to abide by all my previous instructions. Don't talk about this case amongst yourselves or with anyone else. Don't read any media accounts about this case, and don't do any independent research about this case. So, we're going to reconvene tomorrow morning. I would like to start at 9:30, unless there's any jurors who can't be here at 9:30. We're going to start at 9:30. There's going to be closing arguments. There's going to be legal instruction, and then I anticipate you'll be getting this case for deliberation sometime around, I would guess, the lunch hour, and that's when we'll begin deliberations. Okay? So with that, I will leave you for the night, and excuse you for the night. Thank you for your attention. Thank you for your patience. The jury can be excused.
Please rise.
All right. Anything further we need to discuss?
That's thank you.
Very good. See you all tomorrow morning at 9:30.